Item 1.
And Code 5, did the Code 5 grant you the permission?
Yes.
But how will Code 5 grant you the permission when he is taking up bench 5?
The Lordship just directed the court master to send the file.
It has to be given by Code 7. He's taking up bench 3. Anyways, my matter out here, which is pending, is only not on respect to any contempt matter. I'm only taking up the writ petitions. Contempt matter will go to the appropriate court. Yes.
That's on the last occasion, my lord, when your lordships rose, my lord. We were on the report because my friend, my lord, on that day, by an additional affidavit, placed the one-man commission report with us. So we're just going through the report because my friend's contention was that no witnesses were examined, no evidence was led, except that it said it went through the trial court records of the criminal case, it went through the records of APSC, and the commission gave a report. Now, my lord, as your lordships recall, my lord, my submission in a nutshell was that the commission, my lords, has flouted the safeguards under 8B and 8C. I had placed the judgment before your lordships to contend that the violation of section 8B and 8C, my lords, renders the report void. All consequential proceedings, including the recommendations, findings thereof, are void and not binding. That law is clear, my lords. Now, my lord, the issue is, my lord, that the commission, if a lordship sees, my lord, issued a notice to the petitioner, asking the petitioner to file a written statement. My lord, thereafter, my lord, the petitioner submitted a reply, and my lord, some of the petitioners, as my friend also said, my lord, went and inspected the records. And that is it, my lord. After that, nothing was heard from the commission till the report was delivered. Now, my lord, the report of the commission, my lord, I'll just give a nutshell of the report. The report of the commission shows, my lord, that the commission proceeded as if it was adjudicating a show cause notice. That a show cause notice has been issued. This is the reply which has come. I don't agree with the reply. These are the shortcomings insofar as the reply is concerned. And then stated that there are anomalies, they were involved in malpractices insofar as the examination was concerned. That's, my lord, in a nutshell, is the commission's view. Now, what the commission does is this, my lord. Commission summons the investigating officer, a gentleman called Panisar. Time and again, he comes with the records of the criminal case. And the records of the criminal case is perused by the commission to render findings, my lords, against the petitioner. That apart, my lords, the commission by an order deputed, my lords, the advocate for the commission, the DECA, and, my lords, a gentleman called Vaishya, he was the inspector of police, to appear before the special judge, who is, my lords, conducting the trial, and to take inspection of the records and obtain certified copies of the record. And all theirs have been obtained for the court, my lords, for the commission to hold, my lords, and pass pictures, my lords, against the petitioners. Now, one aspect of the matter, my lords, my friend, may not be correct that no evidence was laid before the commission. Because the report shows, my lords, that there were initially, my lords, notice was issued to the public. And there were, my lord, around 9 memorialists, my lord. They are called memorialists. They are respondents to the notice who submitted the response before the commission. And the commission took those responses, my lord, at face value and has rendered findings in the report. That's one. Secondly, my lord, there are 2 other witnesses whom the commission examines on oath. Commission, my lord, summoned one witness called Dr. Mrigen Saikia. He is examined on oath. And that oath, my lord, is extracted, my lord, in the report. Then, my lord, he summons one Pavitra Koibatra, who was assistant controller of examination, and his statement is also taken on oath. So, my respectful submission is this one. Ultimately, my lord, it relies on FSL reports. It relies on reports of the investigating officer, which are tentative reports, my lord, before the trial court. Those are, my lord, material collected during the investigation, which will have to be, my lord, translated into legally admissible evidence before the trial court, my lord, to ultimately for the trial court to deliver a judgment. Now, those tentative material, my lord, the commission takes it. It obtains the records. and renders finding. Well, my respectful submission is, my lords, 8B requires the commission to give those safeguards to those persons against whose conduct has been inquired into. And B, my lords, if the observations or findings are going to impact on the reputation of that person, then 8B obligates the commission, my lords. It does not obligate the party. The commission, my lords, to give the safeguards by calling that person to appear before the commission and, my lords, to lead evidence in his or her defense. Now, my lords, the law is also well settled. Your lordship last time put it to me, my lords, and I agreed, my lords, in Kiran Bedi's judgment says that compelling an 8B notice, my lords, to disclose the defense at the very outset violates his right under 8B. When the commission, my lords, asked these 8B notices, well, I must point out to your lordship, my lords, the commission has overlooked the provisions of 8B and 8C, my lords, in the entire report. Commission says, my lords, maintaining the judicial discipline of audi alteram partem, all persons with the slightest of involvement in the alleged anomalies and malpractices have been provided with the
That's
opportunity
page 787.
Great. So, my lords, commission says that as a person trained in law, I have to maintain my judicial discipline, my lords, and the judicial discipline requires, my lords, the commission to keep audi alteram partem. I respectfully submit, my lord. This is the error.
No, you see, Mr. Chaudhary, there are two aspects. One is the report.
Yeah.
The report is, maybe you may challenge the report that this is a different thing, but the report is to be placed before the government, which is recommendatory in nature,
Yeah.
and the government may take a decision or take steps against to this, whether it is accepted or not. These are absolutely within the
Yeah.
government. So the report as a whole remains with the government. We are not concerned.
Yes.
We are only concerned out here that in view of the violation under 8B and 8C, the report cannot be applied against.
I'm grateful. And
So
if a lordship-
therefore, the report may remain,
yes,
but that findings of the report
Are not
cannot be applied against
I'm
you
grateful.
solely.
and
In fact, if you see the judgment of the Supreme Court in Goa Foundation,
yes, ma'am. Yes, Goa Foundation.
Mr. Kohli, I will also implore upon you to have a look at that judgment of Goa Foundation. It's a very interesting judgment on the mining leases. Now, what has happened out there? There was a Justice Shah commission which was appointed. Mr. Shah did not follow, although the issued notice similar to this, didn't follow 8B and 8C. Then what has happened is the matter came up before the Supreme Court on this aspect. Although the petitioners out there challenged that 8B, 8C has not been followed, so therefore you can't take into account this report and all. But the state of Goa said, okay, let us not look into this report. We have other sufficient materials. And the court said, okay, without solely relying upon the report, if you have sufficient materials, go against these mining leases. Thereby, the report, which is there absolutely within the domain of the state to accept or not, remains as it is. And the Supreme Court also observed that this report, we keep it. Let this report remain. But that shall not be used against the mining lessees. Now, applying the same principles, we can very well say out here, admittedly, whatever may be, it appears that there is what the commission, the learned commissioner had done is, he took it up as a concept of what you call following the principles of natural justice. Principles of natural justice is different from what is there in 8B and 8C. Principles of natural justice otherwise does not require that there should be a presence of an advocate. Principles of natural justice does not require that he has a right of cross-examination of a witness. These are not there. What is there? You give him an opportunity of hearing, and if he comes up with a particular thing, take into consideration his stand also. If he wants to reduce some evidence also, look into it. So these safeguards which are otherwise given under 8B and 8C are exceptional only for those persons which comes under 8BA, 8B1. Only these two persons, not against everybody. So therefore the question is, the report may not be applicable as for these people, but you still have other evidence. And it would not be proper on the part of the state also, taking into account the importance of the proceedings which the state is initiating, to solely take only the report and then issue a show cause, which I think the state must have been properly advised in that regard.
Yes, Lordship. I was actually making
therefore,
note.
If you see, there is one chapter in that report itself, in the report, where only it is being dealt with as to how the proceedings have gone. It doesn't appear from the report that how the proceedings, whether the commissioner had fixed a particular procedure prior to that, because otherwise he has dealt with everything, right from the initiation of the filing of the PIL to the time when the notification was issued. What was the relief sought for in the PIL? All these things they have taken into account, but there is no mention in the report as to what is the procedure to be followed. But in a particular chapter, which is at this page 787, that particular chapter, there he says that as per the judicial principles, I'll follow the principles of audi alteram per partem. It's true. But that is not limited in a commission of inquiry the moment you issue a notice. The moment you are issuing a notice, you presuppose, or it is therefore a self-admission on the part of the commissioner that these are the persons who may be affected. Because otherwise, you normally issue a notice. Because if you see the report also, you see the moment it has come up, the first time when after the commission of inquiry was formed, notices were issued by the secretary out there to all concerned, asking them to come up and
Rule 5.
and against that, around 8-9 persons have given certain statements whom he had the report, the commissioner have referred to as the respondents therein. Whether it was taken on oath, I think it must have been taken into on oath and all. Another very important aspect, if you are relying on a statement of oath, it would become an evidence in chief. Then this particular person has a right. Now, another very pertinent issue is, if you see the show cause notices, Mr. Kohli, they refer to that these are the marks which are being found in and as so and so. There is some manipulation of so and so, and therefore I asked you, what do you want to say? But
And inspection.
anything subsequently taken, this was the notice. But if you see the proceedings of the report, which is also mentioned in the report, there were subsequent things which were taken pursuant to that. If that was also not informed to the person who is going to have affected, his right of heard, even applying simply without 8B and 8C, the principles of natural justice is violated. So if you look into that judgment, you have anybody has the Goa Foundation?
We'll open it on the online. We are opening it online.
Hmm?
We are opening it online.
Oh, please.
That's what my colleagues are doing.
Yes, kindly come to paragraph 14.
Lordship, just share the a citation if I may.
Citation. 2014 6 SCC 590.
590. We have it.
And another very interesting in this judgment is the state of Goa it appears, have also taken a very right stand. Instead of, it would amount to when a high court or a Supreme Court judge have already looked into it, and to say that the report is otherwise or passing an order to the effect that it violates 8B and 8C and all, say that okay, we are not going to only solely rely upon that. I'll come to paragraph number 14. See the submission made by Justice by Mr. Venugopal at paragraph number 11.
11. Challenge. May I read it for Lordship?
For your convenience.
As we have already noticed, in the cases transferred from the Bombay High Court to this court, the mining leases have prayed for quashing of the report of the Justice Shah Commission. Mr. K.K. Venugopal, learned senior counsel appearing for the mining lessees, submitted that the Justice Shah Commission did not issue any notice under 8B of the Commissions of Inquiry 52 to the mining lessees, giving a reasonable opportunity of being heard in the inquiry and to produce evidence in their defense. He further submitted that the Justice Shah Commission also did not permit the mining lessees to cross-examine the witnesses, to address the commission and be represented by legal practitioners before the commission, contrary to the provisions of 8C of the Commissions of Inquiry Act. He submitted that even otherwise, there is gross breach of the principles of natural justice and fair play by the Justice Shah Commission, and therefore the report of the commission was violative of Article 14 of the Constitution. He submitted that the report of the Justice Shah Commission should therefore be quashed. In support of his submissions, he relied on Kiran Bedi, State of Bihar versus L.K. Advani, and Tulsi Ram Patel. Mr. Mohan, shall I read 12 or go to 14 straight, Lordship? I'll go to 14, Lordship, which is the holding.
Yes, paragraph 14.
13 is Mr. Atmaram Natkarni. We find that 8B of the Commissions of Inquiry Act 52 provides that if a person is likely to be prejudicially affected by the inquiry, the commission shall give to the person a reasonable opportunity of being heard and to produce evidence in his defense. And Section 8C of the Commissions of Inquiry Act provides that every such person will have the right to cross-examine and the right to be represented by a legal practitioner before the commission. As the state of Goa has taken a stand before us that no action will be taken against the mining lessees only on the basis of the findings of the report of the Justice Shah Commission, without making its own assessment of facts and without first giving the mining lessees the opportunity of hearing and the opportunity to produce evidence in their defense, we are not inclined to quash the report of Justice Shah Commission on the ground that the provisions of 8B and 8C of the Commissions of Inquiry Act 52 and the principles of natural justice have not been complied with. At the same time, we cannot also direct prosecution of the mining lessees on the basis of the findings in the report of Justice Shah Commission if they have not been given the opportunity of being heard and to produce evidence in their defense and not allowed the right to cross-examine and the right to be represented by a legal practitioner before the commission as provided under sections 8B, 8C respectively. We will, however, examine the legal and environmental issues raised in the report of Justice Shah Commission, and on the basis of our findings on these issues, consider granting the reliefs prayed for in the writ petition filed by Goa Foundation and the reliefs prayed for in the writ petitions filed by the mining lessees which have been transferred to this court.
So therefore, the commissioner's report may have castigated the petitioners out here, saying that they have been involved in all these things. But the commissioner's report also shows various evidences which are there, that this is there, and on the basis of which this is there. These are independent materials. Now, in this case, there is a question of the mining leases, the show cause notice, and all these things will happen out there. That is here. But here you have a procedure which Rule 9 provides. Rule 9 categorically provides that you will inform him all these documents or what are the basis on which you are following.
The discipline.
And he has a right of statement of event. So there is a thorough procedure given, and the law of the land is also there to that effect, by which they are being protected by in all stages out there in a particular inquiry provisions. So therefore, instead of only relying upon that report, because you see the words used, not solely on the report, but this report gives indications. You have those. For having what do you need? For a departmental inquiry is limited only to the fact that it should look into you don't need anything approved beyond reasonable doubt, which you may require for the criminal trial. Here, it is only on the grounds of probabilities. So that is enough for you for getting those materials. Those are there. So why is the state only insisting on proceeding with the show cause of the departmental proceedings only on the basis of the report, which you also know that this particular report alone, and when it is the mandate that you are to give these evidence, on the basis of a report, it cannot be. You cannot have anything against, you cannot form the basic probability cause against the petitioners only on the basis of that report. If the state is willing to do so, then it seems that the state is not seriously interested in pursuing with these departmental proceedings.
I will satisfy Lordship. I have heard what Lordship has said. In fact, Lordship, in fairness, also pointed this out. If I may, Lordship, for a few minutes only. Everything is going to come down for Lordship's consideration, and what is also fairly their argued case. Is there a violation of 8B and 8C? And then Lordship was also pointed out last time, Rule 5 under the rules. This was the crux of it. So basically, now in Goa Foundation Lordship, the slight difference, there is no fight with the proposition in the L.K. Advani case or Kiran Bedi. 8B, 8C are mandatory. They have to be complied with. And that is also our stand, because that is the law. We cannot have a stand contrary to that, and we don't even have that. The question is, has it been complied with or not? Or is there a violation of the same? The second leg, Lordship, is that were they given an opportunity and was a cross-examination denied, or was that opportunity not considered? It can be a two-player, neither a denied if asked for or not considered. Now, first, Lordship, respectfully, I must point out that, yes, Lordship, under the disciplinary procedure, there is a procedure. This is not, the report or the commission is not a disciplinary procedure. We know it's settled law. In fact, we also are grateful because Lordship on the last date made it clear that Section 3(4) is not mandatory. That aspect was bothering Lordship in the previous date, but Lordship, before even I could argue, said it is not mandatory. The ATR, for completion of that fact, the ATR stands now submitted before the Assembly in February this year. Last year, Lordship, 17th February, the report was placed. 19th February, the ATR is placed. Now, Lordship, the point that really comes is, was any material beyond the documentary material looked at by the commission with regard to any of the petitioners here? Let's keep it to the petitioners for a moment. We will take Priyanka Deka, which is sort of a lead matter, just to make it easy. We have also, Lordship, today I must point out, and we are grateful for the time that Lordship gave us, that my colleagues have gone through the entire annexures, report, everything. We have brought the originals also, so that if we refer and show something, we can show Lordship the originals. We will take one case study only, just to save the time of the court and be efficient about it. Now, Lordship, two aspects will become this. We are, Lordship, now there are two parallel fronts to the argument, if I may just place for your consideration. One is the petitioners invoking the writ jurisdiction, coming here, raising the questions, and writ jurisdiction is the most important jurisdiction, I would respectfully say, for the Constitutional Court. They have invoked that. In that, one aspect which is relevant is, have they come with full disclosure or suppression? That's one aspect. And I'm not saying that this is an alternative to my argument. I'm merely placing that this is a consideration for Lordship also. What is critical is, and as Lordship just himself mentioned, that they have inspected. So there was a notice, they have inspected. The fact that they inspected has by many of them not been specifically disclosed. So therefore, Lordship, the question will then come on the nature of 8B. And I'm going to delve in that for a moment, very shortly. The second aspect is, on 8B, if the word 8B notice is not written, would that be, in effect, harmful in terms of assessing whether a notice was issued or not? Respectfully, that is the settled law is no. In substance, 8B has to be complied with. And that's it. The pro forma is not specified. The language is not specified. 8B is the high threshold, mandatory threshold, in which it is the law is settled that if you are going to inquire into the conduct of a person and it may be prejudicial to that person, you have to give the person an opportunity to do so. 8C is only in the case if you are going to depend upon any person's statement, has to be on affidavit, Lordship. And I will just come to the Act because the Act makes an interesting read. Has to be on affidavit. If you are relying on such evidence, mandatorily, you have to give the opportunity, as Lordship himself said, that is an examination in chief. The cross-examination right has to be there, which also gives the opportunity to the person whose conduct is being inquired into to adduce the presence of a person whose evidence they may wish to. In that case, obviously, there won't be a cross by that person, which the section makes clear. Now, therefore, Lordship, in our case is that 8B was complied. That is our case. Now, Lordship, for a moment, if I may respectfully say, let's go to the Act. So I just wish to show Lordship three things. I'm not dealing with section 3. It's out of the way. There's a section 4. We should see section 8B. We have in context seen that, and we must see rule 5. The argument that I will place for Lordship's consideration is that 8B is the highest threshold qua the person whose conduct is being inquired. Rule 5 is a separate situation. And this will become important in the judgments and the distinction. Rule 5, Lordship, is in the nature of eliciting information at the beginning, which may include even the person. Rule 5 is, I come into being as a commissioner of inquiry. That is now functus officio. The commissioner of inquiry has done its report. Its task is over. It's a fact finding. The 7-judge bench clearly says it's only no accuser, no accused. It's for the mind of the government. And as Lordship has said so.
7-judge judgment is only stated by Justice Chandrasud. It's a concurring judgment. The issue in the 7-judge judgment is a different. Whether the state, what was the actual
Lordship, respectfully, the 7-judge of the Karnataka Commission.
The state of
Yes,
Karnataka versus Union of
Yes,
India,
yes.
1977 judgment.
I'm sorry, Lordship, Father Chandrachud is there too. I stand corrected.
So there, the issue involved out there was as to whether the center could appoint a commission in respect to
Yes,
acts
Lordship.
which had been done by a chief minister of a state.
Yes, Lordship.
That was the issue.
Yes,
that was
Lordship.
the prime issue where Justice Beg had delivered the majority.
Yes, Lordship. I'm grateful.
Justice Chandrasud had given a concurring opinion where he led into all these things.
These
That
issues.
is another
fair.
thing. We duly respect that concurring opinion. But the only thing is, whether it is an accuser or accuser, I'm not on that. Mr. Kohli, kindly appreciate one thing. When you are referring to section rule 5, first of all, the procedure, the commissioner in the report does not say that he is going to adopt the central rules. Anyways, let us say that it automatically applies.
Grateful.
If it automatically applies, Rule 5 says that at the time when the commission takes up the matter, the commissioner will issue notice to all. And those persons who come, means this is at the stage of initiation
Grateful.
and not at the after taking any bit of evidence. This is very interesting. There's no evidence taken at that point because the court, the commissioner just enters into the reference. Then the commissioner issues notice, which has been done out here by the secretary to the commissioner, and issued notice. Now, if it is a notice is given, anybody or the respondents out here has to give, or anybody interested can very well come up out there and say that this is my affidavit and this is the affidavit on which I am putting all my facts. I hope these 8 or 9 persons whose things were taken into consideration in the first part of the report, those persons have submitted on affidavit. Let's assume. Once that affidavit is being given, then the commissions on certain prima facie evidence being evidence or any materials coming into light comes to a finding that yes, now look here, there is a chance if I go forward without giving a notice to anybody else whose reputation is to be harmed,
Grateful.
it will be in violation of 8B.
Wait.
So therefore, the commission, this is not spelled out in Rule 5.
Yes, Lordship.
This is a statutory provision given under 8B. So a notice has to be issued to him. This is also held in Kiran Bedi's judgment. The moment the notice is being issued to him, you tell him that these are the basic things which we have got it. And on the basis I feel that your reputation or you will be affected by the inquiry. And therefore, I'm asking you to say, if you have anything, kindly say. These persons receive the notice and say that, look here, we have got our job by doing all these things properly, and we have done all these things. Then the commissioner out here further proceeds with the inquiry. And then he takes some more evidence or materials comes to light, which affects these persons, even without going into 8B and 8C. These materials, it forms a part of the commission's report. It violates Article 21 because of that, as it violates the rights on the principles of natural justice without going even into 8B and 8C. Now, my question, Mr. Kohli, is why is your state only insisting on proceeding with the departmental inquiry on the basis of the report and not other materials which are being indicated in the report? If you are proceeding on the other materials which are indicated in the report, you can very well proceed. There is no quarrel. Therefore, this is, I have given you the way out is paragraph 14 in Goa Foundation, by which you can very well proceed. You have 9, you proceed with all other materials.
So,
but why you are insisting that this court should set aside, or is it the state government wants this report to be set aside by not taking into account that why should we trouble the legislature in doing it?
Lordship, that I would dispel. I would dispel immediately.
Well,
and
it's not necessary. Yes, as I said at the opening out here, I said that the report will remain all along. The report is not to be set aside because the report is between you and the commissioner. I have nothing to do with that. But if the report affects the reputation of somebody, that report cannot be applied. That's all.
Yes, Lordship. And I have to say that even on the last
you have the materials, why you are not proceeding on the basis thereof?
Therefore, Lordship, now for a few minutes, let's take each one of the judgments, Lordship, including Goa. We'll come up to that. And let me address first. I'm grateful I don't need to labor on 8. I don't need to labor on 5.
Kohli, if you want to go on that line, first show me a proposition of law that merely basing upon the report, you can proceed departmentally. Show me that judgment, that law.
So, Lordship,
because otherwise going into that trajectory makes no sense.
Lordship, there is a PR Naik, Delhi High Court. I had placed it also. I'll come back to it in a moment. In which, Lordship, in our compilation to the end. So just for a moment, Lordship, let me cover the law point completely, including what has flowed from the bench. So, Lordship, L.K. Advani's case was that the commission arrived at findings against Mr. L.K. Advani without issuing him a notice or hearing him. So that was the fact in which the findings are there and the law is settled. Kiran Bedi's case was that there was an altercation or a dharna involving lawyers. She refused to submit. That was the case. In Goa Foundation, as we read it, Lordship, and I bow to Lordship having placed that for in that sense, it has pointed out that stand. In Goa Foundation, again, the commission moved without hearing the lessees. And then the state said, we have other material. And the court also said that, look, there are certain things that the Justice Shah Commission in para 11, 14 says that we will rely in terms of the environment, etc. But qua the lessees, they were not given an opportunity. State is accepting that. We don't want the report quashed, therefore. Now, Lordship, the next judgment which my learned friend had relied upon was the case of Jay Prakash, in which Rule 5 and 8 both have been considered. Once when one reads the entire judgment, in that judgment of Jay Prakash, Allahabad High Court, it's interesting. Again, it's similar to to some extent like Goa Foundation. A notice was sent under 5. The response that came, because give me your stand. That was the response sought. That response was they asked for an adjournment because there was a challenge before the court. Eventually, the report came without specifically giving them an opportunity, and hence there was a violation of 8B. That's the next. Now let's come to PR Naik. In Vijay Bhaskar Reddy, which is the other case, Lordship, we have placed for your consideration, the issue that 8B does not have a pro forma is settled. It has to only be giving an opportunity. So now I come to the last 2 legs. PR Naik is a situation where a disciplinary inquiry is initiated on a report. A notice is sent, and PR Naik, towards the end of it, page 37, if I recall internal, said that once the notice has gone, you have chosen not to respond, or you have chosen not to further respond. The commission will continue. That is one judgment. We will come to it. The last one will be, Lordship, also a judgment of SBP versus 1996 Supreme Court. SBP, that's State Bank of Patiala, Lordship, versus SK Sharma, which deals with the issue of no notice versus no adequate notice, and hence real prejudice. These 3 propositions are dealt with. That no notice versus no adequate notice, and the question of any real prejudice.
SK Sharma is a case of prejudice. You have to show prejudice. But you cannot
No, I'm
come
not.
here.
I'm only pointing out.
You see, SK Sharma is not built on 8B or 8C.
Yes, Sir, Lordship, fair.
8B and 8C are statutory protection.
Yes, Lordship, we are on the same page.
Whereas SK Sharma is a case of principles of natural justice.
Yes, Lordship. I'm just pointing out what is the body of judgments we have placed for Lordship. Lordship, now, therefore, the question that comes is that why is the state only on this? That is the question that is flowing. Now, Lordship, may I just request for today one indulgence? We've carried the original files. May I, Lordship, show Priyanka Deka's finding, which is just one, it's about 4 pages or so, Lordship. What went before the commission? What did the commission see? What transpired after the notice, which is at page 92 to 95 of the paper book, my learned friend's petition. 95, the last 4 lines are the relevant line, in which after saying this is the material against you and all, you may come, inspect, you may place your stand, etc. They give their response to the effect that I have no idea about it, I sat for the exam, etc. So therefore, let us just see that, keeping that in mind, Priyanka Deka's file finally. Because, Lordship, what the issue would be is that at page, I'm sorry. So, Lordship, this is, I'll be showing, Lordship, page 375 of the report, which is the 1130 of the affidavit. Item 2.
Item 2 before your Lordship.
And just before we go that, so that we are done with the Act, Lordship has considered everything. I just wish to show one section of the Act, Lordship, Commission of Inquiry Act, 8B and Rule 5.
In the submission, you also keep in mind, do you want a de novo to do a de novo disciplinary proceedings or not? Or you want that everything is finished? Do you have no other materials?
Lordship, the material actually, why I'm going to just labor on Section 4 of the Commission of Inquiry Act for a moment.
Which one of inquiry?
I also have the original file. If Lordship wants, I can place the original file for Lordship's consideration. I think we'll show that and we'll see it from here. No? You can give the court master the original file.
Yes.
What, Lordship, I'll show Section 4. In the meantime, my colleague is giving the original file of Priyanka Deka, which we have carried with us, which will be the same extracts here, but Lordship will have the privilege of seeing the original file. Lordship, in that sense, I will request you see the original file.
Yes.
So, Lordship, Section 4 is the powers of the Commission.
Yes.
The Commission shall mandatorily have the powers of a civil court while trying a suit under the civil code in respect of the following matters being A to F. A, Lordship is summoning or enforcing the attendance of any person from and examining them on oath, requiring the discovery and production of document. C, Lordship, receiving evidence on affidavits. There are 9 such people who have come after 5, given the affidavits, and let me assist Lordship to say those affidavits are not the relied upon material qua the petitioner. So hence no requirement of 8C. That's the argument. But D is the most important for us, Lordship. Requisitioning any public record or copy thereof from any court or office. So what Lordship in effect happens is that Lordship, the Commission passed
No,
an order.
my question is,
Lordship,
when did you requisition?
I'm coming to that. I'm answering that only, Lordship.
When did you requisition the commissioner?
Yes, Lordship.
Was it done prior to the show cause or after the show?
Prior. Yes, Lordship. That's why I'm.
And have you mentioned it in your report?
Yes, Lordship. I'm showing it.
No, have you mentioned it in your show cause about these materials?
The material is the material given. Same. I'm satisfying Lordship. Lordship may just come to page 238 of the report.
Now we of the repetition.
Is it? Lordship has the 993 of the paper book. Additional affidavit. I'm sorry, Lordship.
Report.
The report.
Where is he? As the establishment. Establishment.
I'm sorry, Lordship. A lot of papers today. Can we give you the original, Lordship? We are carrying the copy. My friend would have it. I'll read it. You'd have it. You didn't access it? Not the file, but you have the report. Lordship, we are carrying this if would Lordship prefer. We have the report. Would they've got the copy, but we've got the original. Yes. Page. Yeah. Yeah. Sure. Yeah, sure. Yeah, sure. Now on the report, Lordship may please come to page 238. Bottom. Running pages 993. Internal is 238.
9.
Lordship 933, running page 993. I beg your pardon, Lordship. Open 92 in the red petition. इसी में खोल दो.
Yes.
Lordship is the order dated 12th of April 21, Lordship. I'll may read. The Commission of Inquiry was constituted by the notification number so-and-so dated 8 July 19 of the Government of Assam in the Political Aid Department under the signature of the Additional Chief Secretary, Home and Political Department to inquire inter alia into the 1. The allegations of anomalies and malpractices in conduct of the civil service preliminary and main exams by the APSC, the results of which were declared on 12th May 2015, and 2. The entire process of selection of the candidates and the role of the chairman and the members of the APSC. During the course of inquiry, certain revelations have been made which have necessitated scrutinizing the answer scripts pertaining to the said examination, i.e. CCE 2013. It is understood that the answer scripts are presently under custody of the learned special judge Kamrup M. Gauhati. In view of the above, Shri Dilip Kumar Beshya, Inspector of Police, presently on deputation to this commission, and Shri Bhaskar Jyoti Sharma, staff of the commission, along with Mr. Nilanjan Deka, learned advocate for the commission, are authorized and deputed to inspect and take the details of the answer scripts as may be found relevant and the copies thereof by visiting the office of the learned special judge Kamrup during office hours. Such inspections, etc., shall be carried out in the presence of any authorized staff of the learned special judge Kamrup Gauhati. The orders passed in terms of section 4. That's why I read section 4. Now, Lordship may see next, pursuant to the above order passed by the Commission, the learned special judge Assam Gauhati, who is in session of the related criminal proceeding, namely special case number 2 of 17, passed an order on 19/4/21 allowing inspection of the answer scripts as desired by the Commission. For a ready reference, the order is there below. This is the order, Lordship, of 19/4/2021, passed by Shri D. Thakuria, AJS. The case record is put up today. Received a letter from Private Secretary to the Honorable Mr. Justice B.K. Sharma Inquiry Commission, who has enclosed a copy of order dated 12/4/21 passed by the Honorable Chairman of the APSC Inquiry Commission. Peruse the order passed by the Honorable Chairman. The Honorable Chairman of the Commission authorized so and so, presently on deputation, etc., etc., and take details of the answer scripts which have been seized in connection with the case at hand. Please mark, on the perusal of the order of the Honorable Chairman of the Commission, it appears that to conduct the inquiry, it is necessary to scrutinize the answer scripts which are in the custody of this court. So, for the ends of justice, the Sheristadar of this court is directed to allow to inspect the answer scripts seized in connection with this case to the above mentioned authorized advocate, police officer and staff. Send a copy to the secretary. Now, this lordship is where it takes place, and this is the material. The answer scripts, which now I will show when we go to Priyanka Dekha, what she was written to in the notice. The notice is subsequent, which is at page 92. So, Lordship, in page 92 of the paper book, Lordship, is the notice sent by the Commission to the petitioner, which is dated 13th of August 2021.
You're referring to Priyanka Dekha, which one?
So, in Priyanka Dekha, first Lordship, I have shown in the report that in April, the section 4 notice went to the special judge. Special judge in April passed an order. Now, Lordship, the notice sent to Priyanka Dekha, which I am respectfully arguing, Lordship, is the compliance of 8B, is dated 13th of August 2021. This is at page 92 of the writ petition, which is item 2 today before Lordships.
So this is of 13th of August 2021.
21, Lordship.
Okay, now let's see the notice.
Yes, Lordship. I'm so grateful. And that date is given at page 95, but we'll see the notice, Lordship. May I please respect?
Page 92.
Yes, may I read?
It is already given 13/8/2021.
Yes, Lordship.
This is the notice.
Yes, Lordship.
Reported 91, the order of the commission.
Yes, that is also there. That is the preceding one. 9th of August 2021. May I read it, Lordship? Upon further scrutiny of the answer scripts and related documents, including the FSL reports, further anomalies pertaining to CCE 13 have been detected. Accordingly, the concerned candidate in whose answer scripts anomalies have been found be informed of way of notice, asking for their written response to the same. They may, however, be provided with an opportunity to examine, inspect all the related documents based on which the anomalies have been found. Thereafter, Lordship, is the 13th of August notice, which is in detail, which is addressed to the petitioner Priyanka Dekha, Inspector of Tax, whereas the government is the first, Lordship, on the Commission of Inquiry. Then, Lordship, the second paragraph. Would Lordship like me to read the first? Yes. Second paragraph, Lordship, is the answer scripts conducted by the Assam Public Commission were seized by the concerned investigating officer of the Dibrugarh police case number so-and-so from the record room of examination of APSC. Third paragraph on 93, first para. And whereas during the course of inquiry, the following malpractices and anomalies are prima facie found against you, as revealed, please mark, Lordship, as revealed from the case records of the criminal case of Dibrugarh police station. So he is only relying now on the documents, no statement, hence no requirement of 8C. Further, as per the FSL report...
No, Mr. Kohli. This is for the purpose of notice under 8B.
Yes, Lordship.
There's a difference between a notice under section 8B and the report being submitted on the basis of other materials beyond what is mentioned out here. Only that.
So now Lordship may come to 95.
93.
Because the material what we are going to rely on and show they will be in the original file, so I'll save the time. Lordship may come, and whereas in the above background facts and circumstances, prima facie question necessarily arises as to how such huge anomalies and malpractices could happen without your active connivance. Now, therefore, you are called upon to respond to the above anomalies
No,
by
no,
way.
Mr. Kohli, prior to that, kindly come to page 93.
Yes, Lordship.
What are the things which you have placed before?
Which I will show in the original report. I can show you.
It's okay, it is here. Na?
Yes, Lordship.
Are you saying that this particular document is not right? And
No,
it's-
Lordship, not
it's
at all.
okay.
It's only
So
clearer
let
to
us
read in
please
that,
see.
but I'll read through this.
Page 93,
I'll
I
read.
refer to an FSL report.
Yes, may I read it, Lordship?
Yeah. As per the
There are
FSL
marks of alteration in the answer scripts of Law 1, Code number 69, book number so and so, by the process of overwriting over the original mark scored by you in the said paper, which is 94. The enhanced mark, which is 114, is also reflected in the final tabulation sheet of marks in the CCE 13 against your said answer sheet, Law 1, Code number 69, book so. For a moment, pause, Lordship. The candidate's name is not there, so everything is by the code. In her case, it's 69. Apart from such alteration enhancement of the total marks from 94 to 114, there are also alterations enhancement of individual marks against answers to questions. The details of the alterations are as follows. Book number, question number 8 and 10. Original mark is given as 3 and 13. 3 is altered to 13. 13 is altered to 18. As per the report of the FSL, the handwriting of the enhancement alteration of the marks in your answer script Law 1 is of Rakesh Kumar Paul, the then chairman of the Assam Public Service Commission. As per the FSL report, there are marks of alteration in your answer script of Law 2, Code number 69 so and so, by the process of overwriting over the original mark scored by you in the said paper, which is 62. The enhanced mark is 102. Over 62 is also reflected in the final tabulation sheet of marks in CC 13 against your said answer script Law 2, code number so and so. Apart from such alteration enhancement of total marks of 62 to 102, there are also alterations enhancement of individual marks against answers to questions. The details of alterations are as follows. Question 1, original mark 7 becomes 17. Question 5, original mark 5 becomes 15. Question 7, original mark 10 becomes 20. And question 11, original mark 6 becomes 16. As per the report of the FSL, the handwriting of the enhancement of alteration of the marks in your answer script Law 2 is of Rakesh Kumar Paul, then Chairman.
As per 1, 2, 3, these are all FSL reports pertaining to Law 1, Law 2, and Sociology, wherein the marks have been changed, and the FSL report says that these marks have been changed with the handwriting of Rakesh Kumar Paul. That's it. Now,
Just one more thing.
Now let us come to 95.
Yes, Lordship.
Whereas in the above background,
Of-
uncircumcised prima facie question arises as to how use anomalies and malpractice could happen without your active connivance.
Lordship.
Now, therefore, you are called upon to respond to the above anomalies by a written statement. If you are desirous of receiving the answer script, FSL report, and the final tabulation sheet showing the apparent variations, you may do so by visiting
Yes,
the office
Lordship.
of the commission during the office hours. Now, let us see. This is the year against that he has denied or whatever may be. Now, let's see how the commissioner decided as regards
Lordship. Fair. We'll show you the file.
from the report.
The file, Lordship, it has, it's, you
In
would see
the
the,
report, it is there. Na?
yes, Lordship is there, but it's more clear. That's the only
Yes.
reason.
Where is the report for?
We've given the file, Lordship.
1130.
Huh?
Page 1130. Running page.
Her reply is at 97, but
No, it's okay.
it's
That
okay.
reply is
Is
not
the
required.
assessment of
Yes.
Priyanka Dekar.
Ha, let us see.
We've given the original file. Okay, Lordship wants to see it here. Open the report here, Priyanka Dekar. 1130 hold on. I'm just, Lordship, opening the report for a moment. Yes, Lordship. May I now open it, Lordship?
Yes.
So it says number 20, Srimati Priyanka Dekar. May I read?
Yes.
She is also a selected candidate of CCE 13 and occupied position at serial number 3 under Inspector of Taxes category. As already mentioned above, the select list was published on 12th May 15. At the time of issuance of notice requiring her to meet the allegations of anomalies and malpractices as found in her answer scripts, she was posted as Inspector of Taxes Unit B, Gauhati. She appeared in the CCE Mains 2013 with roll number so and so and optional subjects of sociology and law. As per the final tabulation sheet, this candidate has secured total 828 marks out of 1400. As reflected in the final tabulation sheet, subject-wise marks secured by her are 196 in general studies, 169 in English, general English, 123 in optional sociology paper 1, 124 in optional sociology paper 2, 114 in optional law paper 1, 102 in optional law paper 2, totaling 828 out of 1400. On scrutiny of the answer sheets, when it was found that there are anomalies in her 3 answer sheets as detailed below, she was issued a notice number so and so dated 13/8/21 to explain the circumstances leading to such anomalies indicating apparent malpractices.
Now kindly come to 1136.
1136.
36.
Internal page.
Page 1136.
Create one.
Significantly, her name.
Lordship, just before that, one para, if I may show, Lordship.
No, I've read it.
You read on Lordship the internal page 380 on receipt of notice. That is the important point.
No, I'm not. I don't have an internal page.
So, Lordship, just
I
tell me.
have
1135,
that I have read it.
which is the husband and the lawyer
The
case.
husband and another some
Lawyer.
or
Yes,
somebody
I'm
has
grateful.
as a
I'm
lawyer.
grateful.
No,
Yes.
these things I'm
Grateful.
now on
Significantly.
1136.
Yes. Significantly,
her name.
her name also appears in the list of names contained in 9 loose tabulation sheets of CCE 13, recovered and seized by the investigative agency of the related criminal case from the rented house of Shri Paul on 12/11/16, Vidage MR number so and so, already referred to up to number of times. The altered marks are from 93 to
Now
123.
tell me, Mr. Kohli, was this a part of your show course?
The 9 tabulation.
This part. Significantly, her name also appears in the list of names in 9 loose tabulation sheets recovered and seized by the.
Was it part of the show call? No, I don't think so. No. Lordship, what is there in the note in the show cause are the answer sheets. The 9-page tabulation is not.
So therefore,
Just
we
one minute.
have
Lord.
taken into consideration something, even without going into 8B and 8C. This is in violation of principles of.
May just hear me for a moment. On this 9-page, 1 minute, let me just complete this. I just need to point out, Lordship, on this notice, 9-page, Lordship, there was another matter happening before the learned DB at that time. There is an order which is relevant because in that there is a specific direction by the learned DB with regard to this 9-page tabulation sheet and the formation of an SIT. For a moment, Lordship may need to see that for completion of facts. It is part of our answer. It's part of the reply. Yes. It is part of the reply. Lordship may for a moment like to consider seeing that. Lordship, my reply for a moment to Priyanka Deka. I wish to show the order of 29th of September 23. Which will lead to also, Lordship, the next round.
With my learned friend's permission, just one point, madam. On that 9 loose sheets, madam, that was proved by the evidence of Pavitra Koibatra at page 1304. And it
13,
happens on 20th October 2021 after the
13,
page 1304, internet page 549.
1304.
1304 running page, madam. He receives a report. I received the notice from the commission dated 20th October 21, enclosing David order of the commission of 20th October.
Where? 1304.
Yes, at the top, madam. Running page 1304 of the report,
That is a type copy. That is the original copy.
which my learned friend filed on the other day, madam.
Understood. He filed 2 things.
Oh, madam,
One is a type
540.
copy of the entire thing,
540.
which 1304, it is not there.
You
The
will also
entire
see
thing
the down
finishes.
below, madam, is the pagination of the report, 549. You will not see, madam.
You know,
Page
I have received.
549.
The report is dated 12th of October 2023.
2014 here. It will be prior, madam.
So yes, so there is nothing to that effect. No, that is what, after reading it, kindly see, I'm reading 1136, where of Priyanka Deka. And which page you are referring to? This is the additional affidavit he has filed. Understood. Because you see, if you see the additional affidavit, it says about 749 to 751 page number, starting index. Annexure 1, copy of the report of the one-man committee of CCE 2013, 752 to 12542. Six, 645. What is the internal page? 549. 549, it is not here. What is this report now? This is another one. No. If this is so, on 2010-2021, after the reply being submitted, did you point out to this Priyanka Deka that look here, there's another person whose evidence we are going to consider? Mr. Kohli, I'm trying the best to help you out. You are trying that the state should, the state appears to be not in consonance with, they don't want the report. It appears because
I would respectfully, Lordship, say that is not the case.
I was a bit very sad to see the state of affairs of the commissioner, because the commissioner had to ask the state so many times to submit certain things. Kindly see this particular report. What does the commissioner say? It's a very sad state of affairs. However, in absence, kindly see page 761. It seems that the state is not interested with the commissioners.
Lordship, I would respectfully say, Lordship, states may be slow in their
Mr.
response.
Kohli, the thing is, I am not going to touch the report. Let the report remain, but you cannot use the report against them. You go ahead with your departmental, or fresh department or de novo departmental on the basis of the materials which you have. In fact, the show cause notice, the notice which was issued to the petitioners, the Priyanka Deka at page 92, is enough as notice for issuing a memorandum of charge under Rule 9. That is enough. Why you are referring to the show cause, only the report? If you take that, that is enough for putting taking up departmental against him.
Lordship, in fairness, and I may point, it is identical in terms of, because the report and the materials.
No, it cannot be, because here this report have taken into many consideration. There are evidence being taken. These are things that, just for example, the thing which I pointed out, the MR. These are things which happen subsequently. If something subsequently happens, forget about 8B. Let us not go even to 8B and 8C. The first thing tomorrow you will see that he has taken into consideration something which is not a part of the report, which was not a part of the show cause, even without going into anything. Means it was done behind the back. So,
if I may use Goa for a moment.
I am giving you the opportunity that don't solely apply on the report. Take the report as your guiding principle, how he has proceeded. Ask your inquiry officer to proceed in that manner by giving him all the materials and proceed. Why are you not doing that, which I am asking you?
This, I have to, Lordship, on the specific query, I can't without specific instructions.
No, not necessary. You don't need an instruction. I'm going to strike out the entire thing. I'll pass the order. You don't require.
Lordship, may I just
instruction
hear
for
the
that.
three arguments of mine. There's three arguments, Lordship. The first is in Goa, Lordship, that judgment which Lordship was so kind to share with us.
Is also a light which the report
Yes,
is giving
Lordship, I
to-
just have a point to draw from there for your consideration. Just one point. In Goa, Lordship, when this point was pointed out, that you can't rely on it because there was no reliance.
Solely.
Just for a moment, the Honorable Court said we are yet going to depend on certain parts to it.
Yes.
Well, yeah, Lordship, so I'm just drawing an analogy and placing for Lordship's consideration. Ultimately, we are in your hands. In this entire report, there is a certain part which is the core material, which is identical. I'm just using the word also, identical, which is related to the answer scripts, etc. And that is also relied upon by the report. There may be other material, as Lordship has pointed. With regard to the state's inquiry, this identical material, if Lordship even says, for example, the state comes back again, it's going to be the same effect at the end of the day. We will be, if
No.
Lordship may just
Because-
hear me for a moment, just one sentence,
No,
only.
Mr.
Lordship, one
Mr.
sentence.
Kohli, I would not say so because of the fact when you are initiating it, can you see rule 9 of the department?
Yes, Lordship, I've gone through it again last time also.
Rule 9(1) says that it is parameter to Article 309 of the Constitution, wherein it says that you cannot impose any penalty upon a person unless and until you go ahead with an inquiry. 1. 9(2) says that you have to issue him a memorandum of charge.
Yes, Lordship.
Page 92 is itself a very
Yes, Lordship.
carefully drafted memorandum of charge.
It
Your
is. I'm
inquiry
grateful.
officer does not need to do anything else.
Let's see also.
Why on earth you are not doing this?
May I just show also the show cause notice and let me just build an argument for your consideration. No more. Lordship may just see this show cause notice in the disciplinary proceeding. Page 46 of the petition, Lordship. Page 46, which is 30th of November 23.
Forty-six.
Yes, Lordship.
Yes.
Once Lordship has it, may I show it? There's something I wish to show on page 1.
Yes.
So Lordship may note that they are show cause under Rule 9, Lordship. Read with Article 311, Lordship. Why the penalties in Rule 7 should not be there. Then, Lordship, it says that it was reported by the one-man commission about anomalies and malpractices resorted to the selection of candidates and with the money and extraneous consideration by the APSC while conducting. Now, 3, Lordship, that you are a beneficiary, which is how it's becoming in terms of a memo, that you are a beneficiary of the anomalies and malpractices carried out by the APSC, that you got recommendation by the APSC for appointment by enhancement of your originally scored marks in the final tabulation sheet based on which the final results were declared. Pause for a minute, Lordship. May just mark. The order dated 28th of September 23 of the DB at that time in a related petition where the SIT got formed and the court said, what are you doing in terms of the others? So that tabulation is dealt in 2 ways, under the order of this court and it's dealt with also in terms of what Lordship saw in the report. Hence, your recruitment to the government service on the basis of the recommendation of the APSC is illegal and you secured for yourself a job for which you are not qualified by using illegal means. Pause. She gets 30 marks more, which makes her qualify. If her original marks were there, she couldn't have qualified. That is what the case is. You are therefore charged with gross misconduct and getting into the government service using illegal means and hence not fit for government service. You are required to submit your written statement in defense within 10 pages, etc., etc. Next page, Lordship may come. Your written statements.
Mr. Kohli, are you trying to say that this show cause notice is not solely based upon the report?
In effect, yes.
Yes. That very well. Don't rely on the report and proceed.
In effect, and this is what they've challenged and got a stay.
Matter over then simple question. But you can rely on the report to do it.
And
you can rely on the report. Report, you keep it. Whatever the state wants to do, do it. if you want to rely upon this, then go ahead. But
This is what we are relying on.
later on, you will have a problem out here.
Of course, Lord.
Because the allegations which is being made, you don't, a person does not file a show cause against this show cause notice. It is against the statement of allegation. Kindly see page 48.
Yes, Lordship. Statement of allegation.
I'm trying to help this.
Yes, Lordship, I'm grateful. I'm
That-
grateful.
that-
I'm only trying to assist and Lordship do my job.
It has been reported.
It has been
by
reported by the
about
one-man commission of Justice B.K. Sharma about anomalies and malpractices resorted for the selection. Srimati beneficiary, she got recommendation and final tabulation based on which also, as I pointed out, the order of this court. Hence, the recruitment of Srimati Priyanka Deka to the government on the basis of recommendation is illegal, secured a job for which she was not qualified using, is therefore charged with gross misconduct and getting into service. So therefore, Lordship, the answer sheets are identical at both places. We are relying on that. The 29th of the September 2023 order is where the SIT got created, which the government did, separate on its own, in which there was also a point from the court.
So what this court needs to do is,
Lordship.
they have filed a statement of defense. They should be given another opportunity of filing the statement of defense by giving you an additional opportunity by providing further documents. Because you cannot rely on this at page 49. That's over.
That's, I think, Lordship, that would be the ends of justice, because ultimately,
Because you see, as I understand,
It's absolutely
and
logical.
HC would only give a right to him to that effect that if you don't follow this, you cannot rely on the report to take any action against me. But it does not say that divorce the report, you cannot take any action. So if you are saying that your show cause notice is sufficient for doing it, only thing is that you need some additional documents to be given, thereby another further opportunity to file another document out here to them or any reply to them. Prejudice is not caused to them, but you cannot rely on the one-man committee report. Matter over.
We are relying on the material, even if they have an additional opportunity, ends of justice will be by participating.
Matter over. Finished. Take it. Yes, tell me. Huh? Show me where there's a bar in doing it. No, show me a bar in doing it. So you see, the thing is like this. When I'm passing an order that they can't rely upon the BK Sharma's, the one-man committee's report for proceeding with the departmental inquiry, you have your defense there already. Otherwise, if he wants to proceed with this without going, huh? No, if they have other, no. If they have, you see, once this is being, your only quarrel out here is about the one-man committee's report. We say that okay, one-man committee report may not be taken into consideration for the purpose of further proceeding with the departmental inquiry. Then they can obviously they have a right to do it as per law. No, very good. No, they yes. I'm not, no. I'm not going to hold that. I'm only going to hold that 8B and 8C have profile right against you, in favor of you, and under such circumstances, the report cannot be used against you. The report, including the recommendations, cannot be used against you, but that does not stop them from initiating the proceeding. Yes. No, para 2 is omitted. No, Mr. Chaudhary, if in the circumstance they cannot maintain it on the basis of this, that is their lookout. You have a good defense. No. I'm giving them an opportunity to provide further documents and thereby giving you an opportunity to file reply. Matter over. You have a right. You can very well take the defense that you see still it hinges upon the order passed by this court that you cannot rely upon the report. There are other materials. There is apparent. There's no required. There's no requirement. Mm.
10th November.
Mm.
With reference to the above enforcement law, I am directing to include in request you to urgently initiate departmental investigation to all concerned officers the report who have engaged in this right? 10th November 2023. Now please see how the file moves, my lord. On 22nd, my additional evidence 579. Additional 579.
What is this?
Given the file notice,
Huh.
how the file proceeds after the report.
No, we are not concerned to that effect. Mr. Chaudhary, we are not concerned to that effect. You see, no. Merely because they have said that on the basis of the the inquiry report, we are proceeding with it. That doesn't mean that they don't have a right to proceed against you. Which one? No, it is not required. No, it is good for you. It is good for you. It doesn't go. It leaves gaps. Otherwise, I was trying to give them a right of de novo initiating a show cause, which they don't know. Which I was trying to give it. Mr. Kohli, which one do you want? I give you that option, either of it. Which one do you want? Option. Either you want to proceed with this by omitting.
I think, Lordship, if-
No, on page 46, omit this paragraph 2. And then we omit this and
What's
here
the
statement of allegation paragraph number 1 omitted.
that is
And
basically
list of
the,
documents, all other documents which you feel like.
I'm grateful.
Matter over.
Just have my
Because
additional.
it is not my duty to set aside a report.
I'm
The
grateful.
report remains as it is, but you can't use against them. And that is what has been stated in Kiran Bedi also. You cannot use.
I think it meets the ends of justice, Lordship. I'm grateful.
Yes.
What your lordship, if I just, for my, what your lordship is saying is, your lordship is holding that insofar as the report of the commission is concerned, since it is in breach of 8B and 8C, the report or the findings cannot be used against the petitioner. That your lordship is holding. So your lordship is holding, my lord, that the report, the recommendations, findings in the report made against the commissioner, against the petitioner are not binding and cannot be looked into
And independent of that, they have the right.
if they want to proceed with the so-called notice.
As for this, they want to proceed or they want to do de novo, that is their local. They may recall this and go ahead with a fresh one.
Then your lordship is granting me prayer. Lordship will have the prayer, madam.
What is the prayer?
Page 36.
Yes. And this will apply to you also.
This is my
Mr. Kohli.
The
I
whole
think-
batch.
The whole batch.
I have one small additional argument for lordship. I'll just take 10 minutes time.
Yes.
So the lordships have seen, my lord, the prayer one is declaring, adjusting the proceedings. And so far as it concerns the petitioner,
Hmm.
gross violation of the rights of.
No, it's okay.
Conferred for 8B, 8C.
Hmm.
And my lord. Prayer D.
Hmm.
Because that order, my lord, some high courts have passed that you cannot restraining the respondents and the forbid therefore acting upon taking any action premised on the ex parte observations, recommendations, finding made in the report.
No. I'm making it clear that they cannot rely upon the report which will include the recommendations, anything. But independently, they have a right, being the employer, to take action on other materials available. I'm making it clear
I'm
because
grateful.
you say,
It is always there, my lord.
Mr. Chaudhary, kindly, the
It is
younger
always
one,
there, my lord.
kindly don't dictate this
Yes,
court.
yes, yes, yes,
You
yes,
say
yes, yes.
this court has the power to mold the relief.
I'm grateful.
Point is this, madam. As an employee of the state, we are the mercy of the state. State is all powerful. My lord. State has the power.
No,
I'm not saying that the
absolutely,
lordship
no,
is the state.
no.
You don't need your lordship's my lord's guidance or advice, my lord.
No, not
No,
necessary. No, making it clear. I'm only clarifying it that the observations of so and so shall not preclude them.
That's all.
That is an observation being made. I'm clarifying it. Otherwise, the entire thing will go. Because I'm not touching on the ERB, except otherwise, the so-called, they may proceed as per the so-called or go ahead with it. They may drop this and initiate a fresh one.
I'm grateful, Lordship.
That is the only thing.
Lordship is granting me prayer.
Yeah, not all prayer A to D. That the one-man committee report shall not be taken into consideration. But only thing is, they can proceed as per law without referring to. That is their only. And Mr. Chaudhary, that is your only case.
Yes, that's my
8B
case.
and 8C, which I'm giving it to
I'm not
you.
saying that the state's hands should be tied forever.
No,
saying that. I
on,
never
a,
said that.
on the basis of other materials. And this is what
That is their
appears to be what is also stated in Goa Foundation.
Goa Foundation. That apart from the report, court said it was, my lord, a report on a huge issue of environmental issues, my lord, pertaining to mining.
Here is a case of huge rampant corruption.
My lord, there, my lord, the court in fact said that you will not look into the report.
That is what I'm also asking not to look into the report.
Lordship.
And because the report, you can proceed as per law.
Now, Lordship, which is why I pointed out respectfully that there is a body of material which is identical. Now, we are proceeding on that, and Lordship is saying under 9 I would.
Because the report is a report which the government asks. If we look into the 77 judgment, the government has asked them, okay, kindly give us a fact finding. And he has given a fact finding. Whether the government accepts or not, that is absolutely within the government, and for that we cannot. But if the report castigates a person without giving him the opportunity under 8B and 8C, that portion of the report, so far as affecting him, cannot be replied against him. That's the simple proposition. Yes, Mr. Chaudhary.
Yes.
Mr. I have heard you a lot.
Just to complete the facts, ma'am.
What?
On
There's
the
no
report,
fact.
on the report, your lordship saw my lord Coimbatore's statement, which was obtained subsequently. There is another statement of Dr. Megan Saikia, obtained subsequently in October 2021, which also forms the basis of the commission. So these are statements, material.
That is why I am saying 8B and 8C has been violated. So therefore, I'm giving you the relief that you cannot ask beyond that. Now the next round of litigation, wait for that to come over again.
Lordship, just one respectful. Lordship, I hope so. We'll go through the procedure.
Yeah.
Lordship, respectfully, only one thing. Lordship, there was a suspension that has been stayed. Lordship is aware of that. In effect, Lordship, that order gets vacated. They are on suspension. I need to be given some time to do this only because the elections are on. My officers, everybody would be busy. So just reasonable time, maybe 45
For
days.
what? For what?
No, Lordship, for whatever material we give them and seek their responses, some time, because everybody is fairly loud, Lordship, busy.
The elections are not coming till 12th of March, I suppose, because there is one inauguration of another bridge there.
I'm therefore seeking some reasonable time. So, Lordship, some reasonable time, that's all.
No, if you don't give it, then it will be in your interest. If you don't
We
give
will
it, the
obviously
proceedings
move
can't
fastest.
proceed.
We will move fastest. We are not
Look out.
desirous of this. What, Lordship, I just need to clarify, my learned friend may not be, and we are grateful for Lordship's indulgence, saying that this amounts to a reinstatement and a fresh. What we are saying, Lordship, is that we will, at this situation, they stood suspended, that is vacated.
No, you do one thing, you suspend him again under 6(1)(c) now. I'm giving you the idea. 6(1) rule 6(1).
That is clear. 6(1)(c) is clear.
Taking into account that there's a criminal proceedings going on.
Lordship, we are ourselves written it in our answer. No, Lordship is not exercising advisory jurisdiction. Lordship is merely relying on what we have stated in our affidavit.
No, Mr. Chaudhary, the younger one, this is what the court does rightly all the time from morning to evening.
Yes, my lord.
Although I must grant it, that's a very interesting choice of words. Advisory jurisdiction. I must say that, Lordship, that's a very, very nice use of words.
That is your lookout. How you do it, I'm not going to say anything on that. My role out here was only limited to this.
My lord, the interim order will be made after.
Huh?
Interim orders to be made absolute.
See, Lordship, what happens?
What interim orders?
Allowing my press in the rate. So the interim orders be made absolute.
What interim orders are there?
The suspension order was stayed and the DP was stayed.
Lordship, I have something to
There
say.
is no challenge to the suspension order.
There is,
Where?
please see prayer.
Sorry.
Please see prayer.
On this, I have something to say, Lordship. They are pressing contempt for reinstatement. Tomorrow morning, they will come up and say that you are pressing for contempt.
No, no, will not.
No, Lordship. So they,
Everything is disposed of. Prayer similar. That's my whole challenge, man. Because I am impacted not when they take action under the report.
Don't worry, I will give you a chance to again have a particular what you call relook on this and decide what to
and give
do.
us an interim protection, Lordship, for a certain short
What
period.
interim protection?
In my writ,
His read.
in my writ petition, my friend is asking for a relief. Anticipatory relief.
No, Lordship.
No, no, I will
ask.
ask
Not
you
a
to-
protection, but
No,
reasonable.
no, what is the term used after 90 days? What is required to be used? No, after 90 days, there is a requirement to you carry out a review whether a suspension is further required, and this you do within 30 days.
Ah, that's fair. That's very fair.
And then if you don't do it, then you have to
Lordship,
reinstate
that's
it.
very fair. 30 days is fair.
That is as per Ajay Chaudhary.
Very fair. Lordship.
All interim orders merges with the final relief.
Of course, doctrine of merger.
You cannot give a final relief in an interim order. Yes.
Just for my the Lordship is allowing my writ and making the interim orders the absolute.
No. What interim orders? Suspension.
They can't continue with the suspension now against me.
No, I'm asking them to review it because it is absolutely their jurisdiction.
This review stopped long back, my lord.
No, I'm asking them to review it within 30 days. If they don't do it, then to reinstate them. That is the only order. You see, when you're at the final order of a suspension, you can set aside the suspension, whatever may be, but I'm asking them to review it.
And just to assist Lordship,
is granting me prayer C also. Insofar as the
Lordship, just one
Not as
important
per
thing.
prayer C. No, that is as per what I gave. No.
Just one thing, Lordship, respectfully, in the interim order, there is a direction of reinstatement.
No, no.
That is the challenge we face.
The interim order cannot direct.
I'm
It is
grateful.
never heard
I'm
of.
glad.
That is, these are things not heard
I'm
of.
grateful.
How can you give the final relief
I'm grateful.
by way of an interim order?
My lord, it's been reiterated by various honorable judges of this court. My lord.
That is the best part, no? When I am taking up finally the matter, it is absolutely on me.
Saying is-
I'm giving them 30 days. You
That's okay.
review it,
Lordship,
and if
excellent,
you do
Lordship.
it, that is your lookout.
30 days is enough, Lordship.
And if they don't review it within 30 days, you have to reinstate them.
Obviously, Lordship.
The relief is there.
The suspension order can't continue after your lordship decides in my favor. I have come, my lord, I have
No,
come with a case.
no. You see, there are two aspects. If you see Rule 6,
Yeah.
if there is a proposal, Rule 6(1)(a),
Yes. The criminal case is pending.
no, that is C.
Yes.
One's also Assam Discipline and Appeal
Conflict.
Rules.
I know we've quoted it in our response.
Yes, my lord.
I know, criminal investigation. Where a case against him.
Where disciplinary proceedings against him is contemplated or pending. This is one. Where in the opinion of the authority aforesaid he has engaged himself in activities prejudicial to the interest or security of the state. 2. And where a case against him in respect to a criminal offense is under investigation, inquiry or trial.
Yes, Lordship.
This is C.
Yeah.
So they will review as to whether it is required or not within 30 days. Don't. If you, Mr. Chaudhary, if you keep on asking me, I will point out more and more things to them. Don't do that. I'm giving you the entire relief. A, B, and D. C also I'm giving you, asking them to do it within 30 days. If you fail, then to reinstate. You
It's
cannot
great. I'm
continue like
grateful for
that.
30 days is
Because then it will be in violation of the Ajay Chaudhary's judgment. Otherwise, it will be in violation of Ajay Chaudhary's judgment.
Para 21, Lordship had pointed out. Para 21, Lordship had pointed out.
What do you want to say? Now, what do you want to say? You said 10 minutes. Mr. Chaudhary, kindly give the way to the senior counsel.
He's already there.
No, he wants the mic.
what I was trying to submit for kind consideration is that a satisfaction was derived by the disciplinary authority to proceed against such department. According to them, there are certain misconduct in respect of which they would like to charge us. Now, what is the basis for forming that satisfaction? The basis was below the report of the one-man commission. Now, your lordship is inclined to hold that this one-man commission cannot be acted upon for violation of the.
Again, the recommendations made in the one-man commission shall not be made applicable against you.
Yes. Now, my lord, the question is, in administrative law, there is a concept of supposing if an action is bad, supposing authorities say this action is, we have taken this action on X, Y, Z ground. Would find that X ground is bad. What survived is Y and Z. Now,
Mr. Chaudhary, the moment I accept your submission, you are in putting your, no, I understand what you are going to say. The entire so-called has to go because it is based upon a report, based upon a report. But you see,
no, I'm not saying that. Because the Choker's notice does not reveal which ground more weight in the mind of the disciplinary authority to proceed departmentally, X, Y, or Z. If X goes, then whole thing must go. Because we do not know which ground weight more, whether the Dikasarma's report or other materials which are available. So, nobody is disputing.
if you moment you say that,
Yes.
again I have to clarify that. You want that?
What
No,
I'm
because why? It is in your benefit if they continue with this so-called without that paragraph. Why you are wanting the entire to go and asking him there? Because I have to tell them. Anyways, I will have to tell them. Otherwise, to go ahead, but they have the right to go ahead.
said that para so and so will be deleted. They will not rely upon that.
Anything in the report, that is what I am saying. That cannot be looked into. But otherwise, if they want to proceed like this or want to go for a de novo, you go. That is your look.
In fact,
Because they have a right to proceed. Now, if they want to go ahead with no, I mean, Mr. Chaudhary, if they want to go with a defective so-called, that is their lookout. But if they want to go with a fresh one by dropping this and initiating again, then they have a right to do that.
And as
Now,
Bishop
the
said,
moment
additional
you are
material-
submitting that, I have to again answer to that. When they get that clarification, do you want that?
And additional material,
That is
lordship
why I
also,
say, don't make that submission.
because we have additional, but we have the choice of an additional material, lordship.
Ah,
I'm so grateful.
Because anyways, your prejudice is not there, taking into account that if it is a defective show cause notice, you can very well raise it later on, one. And if it is otherwise, you are given another chance for filing a written statement of defense.
on one more thing, on the suspension part, Millard, since the substantive order would go, whether they will have power to review would survive. That is one thing.
Which one?
Regarding the suspension part,
Ah.
if otherwise lordship finds that since the DP in contemplation of which the suspension was resorted to, the DP power to go ahead with the DP itself is bad on account of the reasons to be indicated by your lordship. Now then suspension also goes.
No, I'm not challenging I'm not deciding anything on the DP. I'm only saying that you cannot proceed with the DP on the basis of the report.
Hello.
So therefore, the suspension, I'm asking them to review in view of that. And the review will be as per the 10 parameters which I have is there in that judgment. What is that name? Again, I forget.
Lordship.
Ah. They are given the 10 parameters. They will have a look at it, whether these are there or not, taking into account that one post is kept vacant. You cannot fill up that post forever. Did it be in public interest? Because that is the most important thing. Because you can't fill up that post. That these 65 or 70, 80% are stuck out there. Now, what about you have another case as regards parallel. What do you want to say on that?
But if it goes on this count, Millard, then we'll not press that point. Additionally.
And then I will put it, Mr. Kohli, you agree
need
that
to be
in
recorded.
all these cases, the same order can be passed. I'll take it as your
Yes, lordship,
submission.
I think it can be passed, comment to one.
Subject to meeting your lordship.
But lordship, it may be also recorded for that because my learned friend has been fair to say so. So that stand is, if it is going on this, we are not pressing on that either.
On what?
On the parallel, because as Lordship had pointed out, there's a difference of price.
Chal.
Just one last.
Yes, one more. what
Lordship
more?
may note 2014 batch is not under consideration. This is only for 2013 batch.
Yes. All 13?
Yes.
What else?
State has to be, if your lordship is only report in breach of 8B, 8C, they cannot prosecute others also. State should be fair. If the lordship has decided.
Lordship state is fair.
If the lordships decide today that the commission has violated 8B and 8C so far as CC 2013, because all the petitioners of CC 2013, we are not holding the.
Mr. Chaudhary, one thing is that when you have a right under 8B and 8C conferred, don't you have to urge that right? Don't you have to urge that right? Yes, I have this right. And if somebody is saying, no,
Yes. Person has to come before your court. Yes.
he has to come.
Yes.
So
That's
those
it.
persons who have come before this court only, this relief can be granted. Not to all others, because they say that, okay, I have waived my right.
Correct. But my last submission, madam, subject to meeting your lordship. Lordships have been, have heard the matter, madam, very patiently. Kept it today, matter is closed. One, our suspension orders have been stayed by on 6th of December, 2025. Right? 2024, more than a year, madam, the suspension. It's one thing they didn't implement, we got our contempt spending and all that. We are now closing it to the lordship finally. All I am saying is, subject to meeting your lordship's concern, let my lord this stay of suspension continue for 30 days till the review. It cannot be.
Absolutely no. That is a file. That is how can a suspension order be stayed? I've never heard of that.
My lord, it has been.
And,
I've never heard of that.
reinstatement order in January. Reinstatement order.
No, these type of orders.
No lordship not upheld. That would be an incorrect submission.
These are very
No
difficult.
lordship.
May I say,
We were asked to come back before the single term.
the division bench in fact told there is no illegality, no irregularity.
No lordship. No lordship. That's not a complete.
A stay of a suspension order is an interim order. When I'm taking up a matter finally, I have the power to say that that is the horse the point. Now let us look into whether the suspension should continue now. And now, therefore, I say that following these parameters, they will have review within 30 days.
Grateful lordship.
And if they don't do it, they will has to be reinstated.
That's
Then
a
we find you again in contempt.
Till then, my lord, at least they should let them review it, my lord, because they have not reviewed it from after the stay of the suspension. So today, my lord, they will have to take a decision. Lordship is asking them to take a decision. All I am saying, subject to meeting your lordship's concurrence, of course, that let this stay continue for 1 year, 1 month. Let them decide in the meanwhile that yes, we decide.
I'll put a submission of Mr. N. Kohli out there as a senior counsel out here that the final order could not have been passed by staying this. And therefore, I will say that this stay was absolutely not permissible, and this is the final order. Then you, if you keep on saying all these things, now because of the stay, you can claim that 100%.
100% I'm entitled to, my lord.
No,
While interim order it was continuing till
so
then.
you cannot get it.
No.
Yes.
But
You are getting it till then.
Till
No,
today.
from today, you are not going to get anything.
till today I'm entitled to, my lord.
Today, you are going to entitled to only 75% because you are under suspension.
Just only lordship is item 43 lordship, just to point out.
The lordships have done the operation, my lord. It is successful, my lord. Patient can't die
It's okay, no problem.
for 30 days.
Let me come back. I'll dictate the judgment in your presence.
Lordship, just to point out, item 43, the petitioner has not challenged 8B, 8C, and it's the 2014 batch, only for information. So one matter is totally different. Up to item 42, Lordship, it's the identical place of Mr. Chaudhary's clients and Mr. Chaudhary's clients.
No, what about the others?
The Chaudhary's clients are all in 2013.
So Lordship, all matters up to item 42 are 2013 batch.
Yeah.
That means, except one Lordship, which is item 43 is the 2014 batch, the case of Wahida Begum. She did not challenge 8B, 8C,
What is her challenge?
only parallel proceedings.
But, my lord,
And then there is a departmental proceedings. The same principle will apply.
yes.
I just I'm only assisting.
For your lordship's
No, I'm only pointing out Lordship.
Everybody, but no, I'm not, on
That's-
all cases, there is the same order. No, anyways,
sir.
I'll pass the order
That's-
in your presence.
grateful for a patient hearing.
Lordship is coming
Let me
back.
come back, I'll
Yes.
pass the orders.
We're grateful.
Or should I keep it and pass my order inside? Because I don't have any other matters.
Yes, Lordship kept ours only today.
And I'll pass the order today itself.
We are so grateful.
Yeah.
Lordship.
You'll get the order, what do you call typed out copy on Monday.
Yes.
Get it.
Wonderful.
I'll pass it inside.
Yes.
Very grateful.
You'll pass it inside, Lordship. Okay.
I'll
Great.
pass it inside. I will take one matter as the lead matter.
Yes.
Priyanka,
Dutta,
take our Lordship.
and then duly take note of that. You say that this will apply for everybody, irrespective of they have challenged 8B and 8C. But there is one additional affidavit filed by
Yes,
you.
filed
No?
by-
So because of that, we take that for everybody out there, and then you have to proceed. And you don't want to insist on this ground, the parallel one taking into it.
Yes, Lordship.
I'll pass it.